Okay, welcome back. In this video, we are going to talk about how to pursue a default decree. So you e-filed your petition, you properly served the court papers and filed a proper proof of service, but your spouse did not respond by the deadline. What next? So you need to show that you properly completed service of process, all right? And that's going to be through the e-filing of the proof of service. So the acceptance of service, the affidavit of certified mail, or also known as the affidavit of signature confirmation, the affidavit of service by process server. There needs to be a document filed with the court showing that service was done pursuant to law. Now, if you served your spouse in Arizona, then they have 20 days to file a petition, or excuse me, to file a response to the petition. And those 20 days is going to be counted from the day the proof of service is filed with the court. If you served your spouse outside of Arizona, then they have 30 days to file a response. And those 30 days will start from the day the proof of service was filed with the court. If your spouse does not respond by their response deadline, then you can file an application and affidavit for default and mail a copy to your spouse's last known address and to your spouse's last known attorney if your spouse has a last known attorney. So it's really important to do this mailing part. If you don't, it can negate the whole default. So you initiate your case, you serve it properly, you file your proof of service. The 20 or 30 days has lapsed, depending on where the papers were served, and no response has been filed. So at that point, you draft and file the application and affidavit for default, and then you mail a copy to your spouse. Calendar 10 business days from the day you e-filed and mailed the application and affidavit for default, because your spouse gets those final 10 business days to file a response. And if they still haven't filed a response by the end of those final 10 business days, then they're in default. So let's look at the application and affidavit for entry of default. Fill out the caption and then indicate fill out all of this information here in the form. Date and sign, and then you're going to file it and you're going to mail it to the other side. Now, if in your petition for dissolution you are requesting spousal maintenance, then you also need to do this form, default information for spousal maintenance. So fill this all out, file it with your affidavit for default, again, if you requested spousal maintenance. Now, if you served your spouse out of state, you can also do this declaration supporting out-of-state service. So you've done the affidavit, like you've proven service, you've done the affidavit for default, you mailed a copy to your spouse. They have the final 10 business days to file a response, but they didn't. They are now in default. So at this point, there's two options. There's obtaining a default decree without a court hearing, or obtaining a default decree with a court hearing. Regarding the default decree without a hearing, if in your petition you made specific requests for what you want the court to order for property division, spousal maintenance, and then if your case involves kids, legal decision-making, parenting time, and child support, then you can complete and lodge a proposed default decree. On the other hand, if your petition was not as specific or you want to make changes to what you requested in the petition, then when you're ready, you'll want to file a motion to set default hearing. And then at the default hearing, you will testify regarding what you're asking the court to order for property division, spousal maintenance, legal decision-making, parenting time, and child support. Of course, if your case involves children. And then the court will be in a position to enter a default decree. When you go to that default hearing, you want to present the judge with a proposed default decree for the judge to review, complete, and enter. Let's look more in depth at this option of a default decree by motion and without a hearing. Generally, the court may enter a default judgment based on documents in the court's file on motion and without the parties appearing at a hearing in the circumstances described in this rule. However, the court may not enter a default judgment without a hearing that is different from what the petition requested. So if your petition wasn't specific enough or you've changed your mind, then you need to have a hearing. The court may not enter a default judgment without a hearing if the party in default is a minor or an incompetent person, and the court may not enter a default judgment without a hearing if the party in default was served by publication. The court may enter a judgment establishing maternity or paternity and orders regarding legal decision-making and parenting time on motion and with an affidavit of the state, the mother, or the father. The affidavit must state facts showing the jurisdictional requirements have been met and that a default order is appropriate for maternity or paternity. And then if the state requests the default judgment, an affidavit of the mother or the father must establish the factual basis for the finding of paternity. And if the petition requests the entry of an order for current or past child support, a child support worksheet that establishes the amounts requested must accompany the motion, and an affidavit must state the basis for determining the gross income of the defaulting party. Finally, the affidavit must state facts substantiating any other requested relief. So just keep this in mind that in order to get a default decree without a hearing, your petition needs to be really specific. There can't be a minor or incompetent person involved. There can't be service by publication. And then if you're seeking a judgment of maternity or paternity, you have to have even more documents in order. All right, now let's look at, there's more under this rule 44.1. When children are involved or a party is pregnant, then the default decree must include the following: whether either party is pregnant, provisions for legal decision-making and parenting time, a child support order and child support worksheet, and then if one parent is receiving welfare benefits, then the Attorney General's written approval of the child support amount, a certificate of completion of the parent information program, a completed income withholding order, and if the parties are requesting joint legal decision-making, a statement as to whether domestic violence has occurred and the extent of it. And then if paternity or maternity is involved, the identities of the natural mother and father and anyone who has lawful status as a parent or custodian of a child included in the court case conferring that status if it is not the current case. So if you're going to go by hearing, a lot of this stuff can be resolved at the hearing. And this is just helping you determine whether or not you qualify to get a default decree without a hearing. Now, if you do get a default judgment entered without a hearing, keep in mind that within 3 days of you receiving the judge-signed default decree, you need to mail a copy to your spouse at their last known address. At that point, they would be your spouse, but you would need to mail it to them at their last known address. So just keep that in mind. You want to comply with that 3-day rule. And then here's the motion and affidavit for default decree without hearing. So just fill this out to the best of your ability and file it with the court. Now let's look at default decree by hearing. If a party does not meet the requirements for default judgment without a hearing, the party must request or the court may order a default judgment hearing. If the defaulted party has appeared in the matter, that party, or if appearing by a representative, that party's representative must be served under Rule 43 with written notice of the hearing not later than 3 days before the hearing. So let's say your spouse is in default, but they've started filing papers with the court, then you need to serve them with notice of the default hearing no later than 3 days before the hearing. At the default hearing, the court may conduct the hearing as necessary to resolve factual issues, determine the relief to be granted, and to enable the court to enter an appropriate decree or judgment. and a defaulted party is deemed to have admitted every material allegation of the petition. However, if a defaulted party appears, the court must allow that party to participate in the hearing to determine what relief is appropriate or to establish the truth of any statement. So even though your spouse is in default, if you have a default hearing and they appear at it, they could be allowed to testify. So just keep that in mind. The court will not enter a default judgment for any amount of child support accruing before the date of the filing of the petition, unless in the petition or in the notice, the party seeking support has notified the party in default of the time period for which past support is sought, and the amount of past support will be calculated by retroactive application of the child support guidelines. So if you're wanting to seek child support from beyond the month the petition was filed, so from before then, and child support can start to accrue from when the parties start living apart. So you have children in common, you have two households. At that point, child support is owed. And if it hasn't been paid, you could file and then you can seek past support, but you need to put that in your pleadings in order to qualify for it. Otherwise, you'll only get support up to the month that you filed for divorce. If a decree or judgment is entered by default, the party obtaining the decree or judgment must certify on the decree or judgment that within 3 days of receiving the decree or judgment, that party will mail a copy to the last known address of the party in default. So very important. Once the judge signs the default decree, you are required to mail a copy to your ex-spouse within 3 days of receiving it. If service was made by publication and no response has been timely filed, a decree or judgment may be entered. The court must maintain a verbatim record of the default hearing and inquire of the steps taken by petitioner to satisfy the due process standards for publication, of being reasonably calculated to give notice to the respondent and providing the best practicable notice under the circumstances. So there'll be some additional evidence to provide at the default hearing if service was done by publication. Now here is what I put together for you guys for a motion for default hearing. I did not find a set form for this. So all the parts in this red color, that's what you're going to need to fill out in the form before filing it. And when you file a motion, you always need to file a proposed order. So we've also got a proposed order for the default hearing. Here's that form. And again, you're going to fill out the red parts. The court will fill out this part with the hearing date. Okay, so that brings us to the end of the default recording. In the final recording, we'll do a summary of all of the information in this series.